Let's move on to that story of Kotak Mahindra Bank, the first major private bank to, in some ways, challenge an RBI order. This all pertains to the RBI's decision not to allow Kotak Mahindra Bank to reduce their promoter shareholding using preference shares. Now, just to give you a little bit of a background, back in August, Kotak Mahindra Bank had said that Uday Kotak is looking to reduce his stake to the required 20% using preference shares. That proposal was sent to the Reserve Bank of India for approval. The RBI came back and said that this route is not allowed as a means of stake dilution. Kotak Mahindra Bank, in a statement today to the exchanges, says that they went back to the RBI to explain their viewpoint, and then they took along with them legal views from a number of eminent legal personalities, and they have not heard back from the Reserve Bank of India. As a matter of abundant caution, they said they have filed a writ petition in the Bombay High Court. Let's get some views on this. There are two ways to look at it. One is a pure legal interpretation, and then there is a broader issue of what the RBI intends to do through some of these promoter guidelines. Joining us on the phone line is Abizar Divanji, partner and national leader for financial services at EY. Abizar, my first question is a legal one. So, Kotak has been asked, arguing back in August and once again that preference shares are permitted under the Banking Regulation Act. So, what's the problem?
No, preference shares are permitted under the Banking Regulation Act, but the directions that were given to the bank basically talked about reducing the percentage of to a particular level of the capital. Now, what the rules at that time did not clearly define is what is capital. And the only definition of capital available under the Companies Act basically includes preference capital. So they say as long as the overall capital is diluted, it's fine. So from a strict legal interpretation of the Companies Act as to the definition of capital is concerned, I think preference capital is included in capital. But if you look at it as to the real intent, which I think everybody knows, it actually does imply to equity capital. So I think it will be at a very low level of argument to be had to say that, are we trying to say that we have technically complied with the law? Legally, yes. In spirit, difficult and debatable.
Abizar, this is interesting. One is Uday Kotak's choice of this route to reduce his shareholding. Second, challenging the RBI and taking them to court. Don't you find this whole approach unusual?
Yeah, so see, the way I look at it is that if there is something which deems to be, a slightly difficult decision and somebody disagrees with it very strongly in the spirit of it, and if that spirit is challenged, I think democracy would allow these to be answered well. And if you look back to the history of what this thing is that RBI fundamentally has discretionary powers within itself, which is also the case with most other countries, by the way. But the Banking Regulation Act does give discretionary powers to the banks to decide how much companies should hold. Now, whenever they come up with licensing guidelines rather, they come up with how that voting power has to be reduced over time. Now, there was no such guidelines when banks like Kotak came in, but subsequently when the small finance bank licenses were introduced, they were given. Now, all said and done, if there is discretion, and that discretion needs to be implemented, I think there is a case to say that why is that discretion not judiciously applied to in specific situations? So when you had to do a Catholic Syrian bank, you were willing to give them a 51%. In some other situations, maybe you would have behaved differently. So I think what the larger argument that needs to be had is if a bank is well governed, has a reasonable, and you know what I mean by well governed is an independent board, a company which can attract the right talent, a company which can generate the right talent. If these things are happening, then shareholding should be a mute argument. And if that is the discussion that needs to be had, it's a higher level of discussion to be had rather than just having one on an interpretation between what constitutes capital.
No, absolutely, Abizar. I think that review is, long now, perhaps desired, given that some of this thinking is a little outdated, perhaps. But, within that thinking, I think one thing that has been pointed out is that even the voting cap has now been raised to 26%. So if the voting cap is at 26%, at least the promoter should be allowed to maintain economic interest up to that point. Is there justification there?
So, yes, technically, and no also, because see, when earlier, even when voting caps were at 10%, I don't think it was ever linked to an economic interest ever. In fact, by the way, never ever has this voting cap been implemented in the Banking Regulation Act ever. If it was, it would be interesting to see how the maths would add up. So I think voting right is a good indicator to say that when everything is at 26%, then why not shareholding also at 26%? A good argument to have. But I think I don't think historically voting rights and shareholding economic interest has ever been linked.
Okay. Abhisar, a quick question on this definition of capital. I think you pointed out that in, say, the Kotak's license condition, that was not properly defined. Has in no, guidelines subsequently that any of these master directions that the RBI issues, have they not specified how they define this term?
No, I don't think, in some situations later on, whenever the guidelines were issued, they've specifically mentioned equity capital.
Yes, they did.
Yeah, but that does not mean that it implies to anything else. Anyway, I don't want to get into that level of a discussion ever because, that would be a very simplistic discussion to be had. That if the intent has always been equity capital, nobody denies that.
Okay. Pratish Kumar, who heads banking and finance practice at Juris Capital, Juris Corp, now joins us on the phone line. Pratish, thank you so much for joining us. Firstly, your view on the latest move by Kotak to move court, and secondly, this whole debate about whether Kotak is following the letter of the law and not the spirit of the law.
Correct. So see, so moving to the court now, this is very interesting because generally banks or financial institutions have never moved against the regulator in court. Now, whatever we are getting that they have approached the court just to save the interest of the investors in the banks. So that would be interesting thing to know that what will be the RBI views on that, because going directly against the regulator in India at least will not be seen as a very welcome step by the regulator. Now, it's very clear that yes, Kotak has in letter they have complied with the laws, because even under 2016 guidelines, the RBI has never clarified, or at least in that specific thing, that it has to be paid up equity share. So I can understand that the intention of RBI was always that there should be diversified ownership. They didn't give license to new industrial houses, and they were very upfront or very vocal about that. So that's why intention is no doubt it's clear. But as of now, I see that since they have complied in letter, so RBI at least should not take anything direct action against the Kotak, that they should not do that.
Okay, I'm just going back to Abhisar for a minute. Abhisar, I had one last question for you before we let you go. In this whole story, who is trying to protect what? Is it Mr. Kotak trying to protect his interests or the bank's interests?
I think it's in the larger interest of the bank, from what I would read. Because even if you look at the OECD guidelines, it actually talks about the fact that wherever there is a substantial shareholder in a company, governance is always better. And if somebody actually takes ownership of a particular organization, I think he can impose governance better as long as that institution fosters development of new talent. I mean, that's precisely what the RBI's principles are on also. When they gave the new small finance bank licenses, or where they gave licenses to the new banks, or even now to a CSB type situation, that they actually want people to take ownership and drive it. As long as that has been done well, I think it's in the interest of the institution.
All right, Abhisar, thanks so much. Pratish, I have one last question for you as well. So essentially your comment was suggesting that if they are basically challenging the technicality of using preference share as a route to do this dilution, they have some legal ground to stand on.
Yes, definitely. And we need to see that what court views and how RBI takes it. But according to me, the only thing that we can achieve as of now is that both RBI and Kotak should go, and RBI should issue a fresh notification, clarifies the intent even in the letter, and then they may give Kotak some more time to do that. I know that there will be economic impact of that, but if they want, their intention is that, then they should be very clear about this.
All right, gentlemen, we'll leave it there. Thank you so much, Neil, for joining us with your views. That's the view on Kotak moving court against the Reserve Bank of India.